Data in today's IT age forms the basis of our day-to-day lives to a great extent. However, when this data is breached, privacy concerns arise. Privacy is not something which an individual is entitled to. It is something which a citizen is having a prerequisite. Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya and I am here today with a topic which has remained in news recently. The title of our today's discussion is Right to Privacy vis-a-vis Data Protection. This topic is important from your GS2 perspective, and that is polity. So we are sharing a lot of information online. Most of this information is personal in nature. In this today's discussion, we are going to see that why there is an urgent need for protecting the personal information we are sharing online. So before we proceed further, let us analyze the points of discussion of our today's session. So firstly, we'll see the background of the topic. Then we'll understand the meaning of the term right to privacy. We'll also see that whether right to privacy is a fundamental right in India or not. We are also going to see why do we need a privacy law. We are also going to study about the recent data protection bill. We'll also analyze a new concept that is known as right to be forgotten. We are also going to see some of the important cases in this regard and the opinion of our Honorable Supreme Court in these cases. And in the end, we are going to see a practice question for your prelims examination and a practice question for your mains examination. So now let us proceed to see the background of our today's discussion. So India is working on a legislation, and that legislation is known as the Data Protection Bill. It has been approved recently by our Union Cabinet. The bill seeks to protect our personal data as well as it guarantees us informational privacy. Now let us understand the meaning of the term right to privacy and informational privacy. So right to privacy in India is an intrinsic part of the fundamental rights that have been guaranteed to us by our Indian Constitution under Part 3. Right to privacy was declared as a fundamental right under Article 21 of the Indian Constitution. So what is this Article 21? Article 21 talks about the right to life and personal liberty. Informational privacy is also an important facet of the right to privacy as has been observed by the Supreme Court. So what do we mean by this term informational privacy? Let us understand this by an example. So whenever you log into a social media app or website, you are often asked to enter your personal details such as your name, your email address and your mobile number. All of this is sharing our personal information online, and the major concern today is the misuse of this personal information. Let me explain how. Whenever I conduct a Google search on some topic, for example, I am searching for address. Suddenly I see that there are targeted ads on my YouTube regarding that, or on my Instagram page regarding that, or on my Meta profile regarding that. That means the companies are using your personal data for their own commercial benefit. Not only this, even our Aadhaar details are often misused when we enter it online. All of this demands that there should be a need of protecting our informational privacy. Why? Because we are the master of our own data. Not only we should have the right to control our personal data which we are sharing online, but also we should have the right to delete it after it has served its purpose. So all of this discussion helps us to contemplate that whether we need a privacy law in place and whether India has a privacy law. Let us study about this in our further slide. Though India is having legislations on various important subjects, but sadly there is no data protection law in India currently. Data protection in India is still governed by the Information Technology Act, but this act is also silent about deletion of personal data online. In fact, the Telecom Regulatory of India has proposed to monitor platforms such as WhatsApp and Telegram because it is suspecting that they are using the personal data of their Indian users for their own commercial benefit. So all of this leads to the point that we need a privacy law in place, and not only we need a privacy law in place, we need a strong privacy law in place to deal with all these issues. As India's data economy grows, it finds itself grappling with regulation in order to catch up with the rich data Indians are sharing every day as they log on to hundreds of platforms. So as I was discussing before, we are logging on to hundreds of social media platforms for our daily needs such as grocery delivery or medicine delivery, and in this process we share a lot of personal data online. So that is why also there is a need to have a privacy law currently. So what will be the privacy law purpose? What will be the purpose of this privacy law? The purpose of behind the data law is to set rules for processing of personal data by the government, companies incorporated in India, and foreign companies dealing with personal data of individuals in India. As we all know that right to privacy is a fundamental right in India, so is the right to internet. In fact, India's smartphone market is, this again brings us to the moot question of our today's discussion, that yes, we need a privacy law in place. Now let us analyze the recent data protection bill that has been approved by the Union Cabinet. The Union Cabinet has cleared the Digital Data Protection Bill or the DPDP bill that essentially allows laypersons to complain to the Data Protection Board of India if they have reason to believe that their personal data has been used without their consent. So this Data Protection Board of India will be going to be a separate statutory authority which will be dealing with our misuse of our personal data. Currently in India, if there is an case of identity theft or online fraud, it is all covered by our penal legislation such as IPC and the Information Technology Act. Once passed, this bill or the law will allow us to approach the Data Protection Board of India directly in case of the misuse of our personal data, and the term is without our consent. This bill also outlines the procedure that has to be followed by the various entities who are collecting our personal data. So this is not the first time the Indian government is making an attempt to legislate on the data protection. A similar attempt was made in 2019, but last August 2022, the government withdrew from Parliament an earlier version of the data protection bill, that is the Personal Data Protection Bill of 2019. That had been almost 4 years in the making due to the concerns which were raised by various stakeholders. The proposed law, that is the current data protection bill, will apply to processing of digital personal data not only intra-country, that is not only in India, but it will also apply to extraterritorial operation, that whenever there is an export, import, or there are some other circumstances also that involve sharing of our personal data, this bill will also apply on those sharing of personal data. It also mentions about data fiduciaries. So who are these entities known as data fiduciaries? They are required to maintain the accuracy of data, keep data secure, and delete data once their purpose has been met. So I was discussing this before also, that this bill recognizes right to delete our personal data, and the data fiduciaries are required to delete the personal data if it is no longer viable. Now let us discuss the new concept of right to be forgotten. So right to be forgotten as a concept is debated globally and in India. So what do we mean by this term right to be forgotten? Right to be forgotten, if we talk about in simple language, means that we have the right to get our personal data erased from all online platforms if it is no longer viable. So what had happened was, how this concept came to India, that there was a person named as Mr. A. He was acquitted in the NDPS Act by the Delhi High Court, and he approached the Delhi High Court stating that he is not able to get employment because whenever an employer runs a background check on him, the Delhi High Court judgment crops up, and this has led to him being unemployed. The Delhi High Court granted him the relief and asked various legal websites and the Google to block the judgment. So this was the first recognition of right to be forgotten in India. The Court of Justice of European Union in 2014 has recognized the right to be forgotten in 2014 in the Google versus Spain case. In this case, the court acknowledged the right of the Europeans to have their personal data removed from commercial platforms such as Google if their personal data is no longer viable. So this was the beginning of right to be forgotten from the Google Spain case, and as I have discussed, the Delhi High Court recently has granted relief to this person A who has been acquitted in the NDPS case. So in the Indian context, right to be forgotten has been recognized by the Supreme Court in Justice K.S. Puttaswamy versus Union of India 2017, notably known as the Aadhaar case. And the Supreme Court has noted that the right to be forgotten was a part of the broader right to privacy. So the Supreme Court has recognized that there is a right to be forgotten and it will be a part of broader right to privacy. But in India, this is still a developing right, and the Supreme Court has still not declared it as a fundamental right. So what are the issues in implementation of right to be forgotten if it is enacted in India? So the first issue is the enforcement of fundamental rights against private persons. As we all know, fundamental rights guaranteed to us by our Indian Constitution can only be enforced against the state. But if right to be forgotten is enforced, it allows enforcement of fundamental rights against a private person as well. Secondly, the courts are also not clear in their interpretation of the right to be forgotten, and ambiguities exist in various interpretations given by various courts in India. So this was all about right to be forgotten. Now let us discuss some of the important cases on right to privacy and the opinion of our Honorable Supreme Court in these cases. So the first case is R. Rajgopal versus the state of Tamil Nadu, 1994. In this case, Supreme Court recognized the right to be left alone as a part of right to privacy. Then in the case of Mr. X versus Hospital Z, the Supreme Court has stated that, for example, there are two fundamental rights in conflict and one of them is right to privacy. Then in those cases, that fundamental right will be enforced which is favoring or which is in favor of the public health and public morality in general. So right to privacy is not an absolute right. It can be overturned by those rights which help in enforcing public health or public morality or public decency at large. Then in the NAS Foundation case 2009, a controversial part of section 377 of the Indian Penal Code was struck down, which punished two adults who are of same sex from practicing private acts in their private space. Then came the landmark judgment on right to privacy, and this judgment is Justice K.S. Puttaswamy retired versus Union of India 2017. As I have mentioned before, this case is notably known as the Aadhaar judgment, and this is one of the landmark cases on right to privacy. The Supreme Court in this case declared that right to privacy as a fundamental right under Article 21 of our Indian Constitution. This landmark judgment has added a new aspect to the meaning of life and personal liberty. So right to life and personal liberty is not only about having an animalistic existence. it recognizes our right to live with human dignity. So, if we have a right to live with human dignity, we also have a right to privacy, as it is an important facet of right to life and personal liberty, as well as right to live with human dignity. However, it is not an absolute law and is subject to reasonable restrictions. As I was discussing the Mr. X versus Hospital Z case, in which the Supreme Court has categorically stated that if a right enforces public morality or public decency at large, it will prevail over right to privacy. So that is why we are saying that it is not an absolute law. It is also subject to reasonable restrictions. This judgment has created a pathway for recognition of various other rights within its scope and ambit. So, the various rights that have been recognized under right to privacy are right to choose a life partner. In the adultery judgment as well, the Supreme Court has recognized right to privacy, and now adultery is also unconstitutional. It is no more an offense. Even right to motherhood also is recognized within the scope and ambit of right to privacy. So with this, we come to a conclusion of our today's discussion. We have seen that right to privacy is fundamental right in India. We have also seen that India strongly needs a privacy law in place. We have also discussed the recent data protection bill that has been tabled in the Parliament. We have also seen some of the important cases and the opinion of our Supreme Court in this regard. And we have also discussed a new concept known as right to be forgotten. Now let us see a practice question for your prelims examination. Right to privacy is an intrinsic part under which of the following articles of Indian Constitution? So your first option is Article 14, second Article 19, third option is Article 21 and fourth option is Article 22. So as I have discussed in my discussion today, that your correct answer will be Article 21, and this was held in the case of Justice K.S. Puttaswamy versus Union of India. Now let us see a practice question for your mains examination. So the question is, what are the concerns regarding privacy in India, and do we really need a strong legislation for data protection? Comment. So kindly attempt this question for your mains examination. I hope this session was insightful for you. If you liked the today's discussion, kindly like the video and subscribe to our channel for more such updates. Thank you.